Johnny and Luan now. I'm one of the co-vice presidents for ACS, along with Mark Bode, who unfortunately couldn't attend today. But thank you all for coming. I want to mention at the top that at 4:30 today, the film documentary about the plaintiff in the Windsor case is going to be shown in room 180. I highly encourage everyone to attend. But today we have 4 individuals who were involved with various aspects of the marriage equality movement. And I saw in the news this morning that New Zealand just became the 13th country in the world to extend same-sex marriage rights. So in light of that, in light of the oral arguments in the Supreme Court heard last month, we're going to discuss marriage equality here in the U.S. We have here Professor Wald, who is a leading expert on children's rights and welfare issues. And his role was really central in organizing an amicus brief for family law professors in California for the Perry case. Next to him is Elizabeth Dooley, a 3L who was part of the Supreme Court litigation clinic, along with 3 other students who were working on the DOMA case. And for her, I'd be curious to hear how going back to classwork is that experience. Next to her, we have Professor Schacter, an expert in statutory interpretation and sexual orientation law. I know many of you are in our 14th Amendment class right now, and I'm very grateful for that because the class is so big that I only got 1 question on panel today. It's quite nice.
It was kind of an easy one, wasn't it?
It was an easy one.
Sorry, I'll do better next time.
But she has written extensively about same-sex marriage issues, and I know she was writing a lot of journalistic accounts in the lead-up to the 2 cases. And next to her, of course, is Professor Karlan, who was co-counsel for E.D. Windsor in the DOMA case. And I know today is a busy day for the Supreme Court clinic. I believe it's an oral argument in the Salinas case as well. So thank you all for being here. I'm going to pass it off to Professor Schacter.
Thank you. Thanks. It's great to see you all as we wait for the decisions to come down. And I thought what I would do is just kind of provide a quick history and overview of the marriage equality movement and how we got from its beginning to where we are now, waiting for 2 really important Supreme Court decisions. And I think if you had asked me 4 or 5 years ago, did I think the Supreme Court would have a marriage equality case to decide in 2013, I probably would have said no. And the reason is this, that on the one hand, the modern marriage equality movement started, it'll be a 20-year anniversary of sorts next month. It started when the Hawaii Supreme Court issued an opinion, kind of came out of nowhere. The organized gay rights movement did not think the time was right to start litigating for marriage equality, so it was a solo practitioner in Hawaii who filed it, and the Hawaii Supreme Court issued a ruling that said that it was going to apply strict scrutiny to the challenge to Hawaii's marriage laws, not allowing same-sex couples to marry, which was basically a signal that that marriage law was very likely to fall. And that was May of '93. And the reason I say it wouldn't have struck me as obvious that we'd be in the Supreme Court now is that what happened after that Hawaii decision was issued, and well before any state in this country recognized same-sex marriage, was an enormous backlash unfolded. One important piece of that backlash is that Congress in 1996 enacted the Defense of Marriage Act, which is the subject of the Windsor case that you'll hear more about in a few minutes. The other part of the backlash is that most states around the country, a majority of states around the country, passed anti-marriage equality laws. In fact, 30 states in all have amended their state constitutions, as California has with Prop 8, the subject of the other case you'll hear about today, to disallow same-sex marriage. And because of that backlash, there was an enormous degree of caution in how the litigation for same-sex marriage equality unfolded. It was a full 10 years, in fact, before any state, and that was Massachusetts in 2003, legalized same-sex marriage. And all of the litigation up until a few years ago was by design confined to state Supreme Courts. And the victories, as in Massachusetts, as in California, until Prop 8 took that victory away, as in Iowa and a number of other states, were all the result of litigation invoking only the state constitution. And that was a very deliberate decision to keep the case away from the Supreme Court, because given the public backlash, given the membership, the increasingly conservative membership of the Supreme Court, it did not look like a particularly good bet to litigate in federal court at all or invoke federal constitutional theories which could find their way to the Supreme Court. That all changed a few years back, around 2009. And two things happened then. One is that a number of lawsuits were filed to challenge the Defense of Marriage Act. And I can remember back before one of the big ones was filed in Boston, the Gill case. I remember getting a call from Mary Bonato, who's a lawyer I've known for years, who argued the case in that led to the first same-sex marriage equality ruling in Goodridge in Massachusetts. And I remember her calling me and saying, we're thinking of filing a lawsuit challenging one section of DOMA, the section that prohibits the federal government from recognizing as a marriage what is recognized in a state under that state's law as a full and legal marriage. And just want to give you a heads up, because I know a lot of professors and lawyers and folks out there are concerned about backlash. And here's why we're doing this. This is a lawsuit that would not require the Supreme Court or a federal court to find a fundamental right to marry. It can be resolved as an equal protection case. If the federal government recognizes anything that a state treats as a marriage when the partners are of opposite sexes, do they have any justification for following a different rule with same-sex couples? So you don't have to say that, the court would not have to say there's an underlying fundamental right to marry, could just resolve it on equal protection grounds. And she was making a lot of calls like that to avoid hysterical reactions about possible adverse consequences. The other thing that happened is that after Prop 8 passed in 2008 and took away, basically wiped out a California Supreme Court ruling which had found that the California Constitution guarantees same-sex couples in the state the right to marry, and numbers of them did during the period that it was illegal. Then in November of 2008, Prop 8 passed. And there was state court litigation about the propriety of Prop 8. That all lost. And right after that last loss in the California Supreme Court, which left Prop 8 in place, a federal suit was filed in what's now called Hollingsworth versus Perry. And that lawsuit, as you probably know, was initiated by the unlikely duo of Ted Olson and David Boies, the lawyers who had faced off against each other in Bush v. Gore. And against the advice, the pleas, the begging, the cajoling of the organized gay rights legal movement, which said this is not the right time to go to the Supreme Court or go to federal court and ask for that fundamental right to marry, Olson and Boies pressed ahead, filed the lawsuit. It led Judge Vaughn Walker to hold a very unusual, extensive trial with lots of evidence. You may remember some of that for those of you who were in California a couple of years ago. He ruled in favor of the couples and struck down Prop 8, ruling that it violates the federal Constitution, both the fundamental right to marry, grounded in the Due Process Clause, and under principles of equal protection. And then that went up through the Ninth Circuit, and it's now come to the Supreme Court. Now, there are issues in both cases. I mean, one of the things that's true about both cases is that the elected officials who ordinarily defend statutes in court against constitutional challenge do not, in either case, want to defend DOMA on the federal side, Prop 8 on the state side. So that's led to a whole set of interesting questions about whether there is standing to appeal and who can defend which measures. And you'll hear, I think, more details from others on the panel about that. So the cases were argued in March. Fascinating listening. If you haven't already heard the arguments, they're widely available online, and I think you will be, if you're interested in this issue, it's well worth your time to listen to them. My strong sense, and of course you can easily be thrown off by what goes on in an argument. There's perils trying to read the tea leaves. But my own impression, I think is consistent with a lot of other folks, is that they are looking for a way not to decide the Prop 8 case. And there are various options that sort of surfaced. One is to dismiss the case as a case that never should have been taken in the first place, a giant kind of never mind. Another would be to hold that the ballot sponsors of Prop 8, who are pressing the appeal because the governor and attorney general don't want to, lack standing to press the appeal. That seemed to raise some concern with Justice Kennedy, who is, as in so many things, the likely swing voter. He, a creature of California and its initiative process, seemed a little uneasy about the idea that elected officials, by virtue of choosing not to defend a ballot measure, could do an end run around the whole institution of direct democracy because there'd be no one to appeal a measure found unconstitutional if they chose not to. There is a fix for that. There is a way he could join an opinion which says that the ballot sponsors, who are not the government, lack standing, while that kind of global risk to the process could be avoided. It could be avoided, I think, if there were simply language written into ballot measures that says if elected officials choose not to defend this, then the people hereby, name or appoint ballot sponsors to do it, or something like that. So there are ways to get around the biggest implications of finding no standing. But it seems like that was the signal that they were sending. Now, having said that, of course, we could all be surprised. In the DOMA case, it seems much more likely they'll get to the merits, although there's interesting jurisdictional issues that you'll hear about. The thing that puzzled me about that argument was that Justice Kennedy, again, seemed very insistent on federalism problems with DOMA being the place that he wanted to kind of plant his flag. And pushed to their limit, the federalism objections to DOMA, which basically say the federal government ought not to fail to recognize a marriage that's recognized under state law. Pushed to their limit and standing alone, it seems to me that's a somewhat problematic argument. Throw a little, couple of pinches of equal protection in with it, it starts to look a little more credible, and maybe that's where they'll end up. So that's about all I want to say by way of general introduction, and I guess Professor Wald.
Okay. I'm very pleased to be here today, and I'm going to take an approach to this that is not specifically around the legal issues in the case, but more of looking at the Perry litigation from a lawyering for social change perspective, and the use of various tools by lawyers who want to bring about social change, and then what Perry tells us about the use of law as a means, the use of litigation in particular as a means of social change. And then we can come back to some of the legal questions that you might want to raise. But I want to talk about some aspects of the case that probably receive less attention and will carry over more to kinds of practices that hopefully many of you will be involved in. And this is an issue that marriage, same-sex couple marriage, that I've been involved in for now close to 15 to 20 years, coming in it from a kind of unique perspective in that I got involved in it as a children's lawyer and as a family lawyer. And on why it was good for children for their parents to be able to marry, and then came at the marriage issue from that perspective. And so I've worked closely for a lot of years with a number of organizations that were primarily gay, lesbian right organizations, bringing the kind of family law, children's perspective to that set of litigation. And as Jane has just said, in that perspective, nobody wanted this to be at the Supreme Court. as cases. In fact, in the 1990s, there was a big debate within the gay community as to whether marriage was a good thing at all. And there was a national tour by Tom Stoddard, who was then head of Lambda, was he at that point, and Nancy Polikoff, debating all around the country, do we really want marriage, or is marriage a bad thing? This was, you have to take into account that this was still at a time when there was criminalization of homosexual conduct, so that thinking about marriage at a point when we're pre-Lawrence and living in a Bowers world, but there was big debate in the community whether this was even sort of an issue, and certainly there was an even bigger debate, or I would say actually less of a debate, whether if it should be an area, should it go through the courts or should it go through the political process, with Tim Stoddard and others arguing for a political process, remembering that when the courts do something, and there are going to be 5 legal issues before Perry that we can talk about, but when the courts do it as opposed to a legislative approach, it necessarily requires framing things, generally not in a moral sense. You've got to put it into a legal frame. You've got to put it into doctrine that fits, and that doesn't necessarily reflect how members of the community being affected want the issue to actually be framed. It also, when it's in the courts, it takes it out of the hands of the community. You're not running a campaign day to day as on ballot initiatives, on legislative judgments. It gets in the hands of lawyers, and it often can turn out not to be lawyers who are listening to members of the community necessarily, and that was a big concern over Boyes and Olson. But with anything that is a potential constitutional right, there's no control over who can bring litigation. So just like in Hawaii, although the national organizations didn't want to bring it, some individuals did. All the way through the country, individuals brought lawsuits that were there. And when I say the framing, let me give you just an example in the context of the case. This was true in all of the marriage cases. It was particularly true in California, where I was involved in the early marriage cases, the California litigation. Do you think of marriage as an equal protection claim, that same-sex couples are fundamentally equal as parents, as partners, as opposite-sex couples, and it's an equal protection claim? Do you think of it as a sex orientation claim, sexual discrimination based on sex orientation claim? Is it a gender discrimination claim? A lot of the early cases were brought with a gender framing. Or is it a due process fundamental right to marry cases? Each of those different framings have very different valence to individuals, to the community, as to what is being thought about as marriage. Even though many lawyers thought that the gender discrimination claim was the strongest legal argument a long time ago, many same-sex couples didn't see it as a gender discrimination problem. It was an equality problem, and framing it as a gender discrimination problem was a problem for many to put it into that box that's there. So doing anything legally puts you into a box, and particularly when you have outside counsel coming in, not part of organizations that are connected to social causes, they will look for the argument that is most likely to win at the courts and frame it in that way, and that also raises sets of tensions, and that happened all the way through the Perry case. So despite the fact that there was a decision, so in California, Prop 22 was passed back in 1999, which was another one of these amendments against DOMA and a non-right to marriage. Most of the organizations that were concerned about same-sex couples and about gay and lesbian rights, didn't want to bring litigation. Thought it was the wrong time for the reasons that Jane said. And also pursued a legislative strategy of moving toward same-sex unions, which were mostly civil unions, but ultimately the California legislature passed a marriage law, which was vetoed by Governor Schwarzenegger. But a very interesting aspect was recognizing that litigation might occur in all of this. A great deal of time was spent laying a basis through legislation for making the equal protection claims in the litigation. So we put a lot of findings of fact into preambles and into other parts of the legislation so that they could be referred to if it came to litigation, that we'd have a very good legislative record that was there. So you need to think about any kind of social change as there are parallel tracks going from ballot initiatives to legislative to courts, and they need to be thought about in a comprehensive kind of way strategically. So then, again, there's always fortuity in all of this. There was not going to be any litigation, and Gavin Newsom decides to grant marriages in San Francisco. Suddenly, it's on the table, and it is going to be in the courts because people are challenging Newsom's right to grant it, and that leads to the marriage cases in California, and the California Supreme Court declaring as an equal protection and on many other grounds a right to marriage in California. Proposition 8 comes about, the voters reverse that, and once again, there's a debate and a decision not to bring litigation because there was thought you can't win in the Supreme Court. Anthony Kennedy was always seen as the swing vote, but that was just too hazardous. And along come Boyes and Olson, who decide to bring it. They are encouraged by some people. They decide to bring it. They also, against the advice of almost everybody that had been involved in all of the litigation, decide to bring a trial and have a trial on the merits. There had been a big concern that if there was a trial, the opponents could put in weak but adequate evidence by not very good experts that would withstand certainly a rational basis test and maybe even other forms of scrutiny. We didn't want that kind of record. Boyce's view was that nobody could withstand his cross-examination, and he turned out to be right in retrospect, and in something that I strongly opposed, having a trial. I had been preparing witnesses in a lot of the trials up until then. Through destroying people in depositions, he wound up with a trial record that was incredibly strong. The other side didn't put on any credible witnesses whatsoever and gives a really good legal basis. But even then, you come down, and I'm just going to briefly do this and then turn it over and turn it to questions, that you're now faced at the Supreme Court with a number of other tactical decisions. Boyes and Olson came into this because they and the people who were supporting them wanted a national right to marriage. From my perspective, I want a national right to marriage also, but we're very worried. And what I've been involved in working with other California law professors is that California lays the grounds, partly because of this legislation, for a very California-specific case. We have, through legislation, said that in every single way possible, same-sex couple unions are the equivalent of opposite-sex couple unions. They can adopt with no preferences one way or another, access to assisted reproductive technologies. There are legislative findings that it's good for children. So a whole record was laid out for a very California-specific decision, which would be very narrow. But Boyes and Olson, of course, want to narrow things so that it becomes a question of how they decide. Then the U.S. comes into it with its 8-state theory that anybody that passed a civil union statute is there. Pam can talk a little bit how the United States got into that position. And then there's the standing issue, and the Ninth Circuit decides on a Romer basis, which is completely different, but people think that Reinhardt wanted to decide on a Romer basis to lay the ground for Kennedy, who is a Romer supporter. So the strategic decisions are very essential. One last point is this case was unique in that particularly the San Francisco City Attorney's Office, but all the attorneys worked with all of the amici in terms of suggesting. They can't control amici do what amicus briefs are going to be what they are, but each amicus brief wound up having a set issue it was focused on. So there were 20 or 25 coordinated amicus briefs, which allowed the main briefs to cover things in less depth because they only had 50 pages, and amicus briefs to take on issue by issue in much, much greater depth. It's often hard to get that kind of coordination or cooperation among amicus. This was a unique experience of the various amici really staying focused on very narrow issues in specific briefs in order to build an entire record.
First of all, Will and Jake, thank you for including me on this panel today. I'm just going to give a brief overview of a couple of things, and then the other individuals on this panel clearly have much more experience than I, so hopefully there will be lots of time for questions of them at the end of that. So the three things that I'm going to touch on really quickly, I'm just going to talk about the jurisdictional issue in the DOMA case, and then I'm going to talk about the two primary arguments for DOMA's unconstitutionality, which are the equal protection argument and then the federalism argument, which you heard Professor Schacter mention earlier. And then the last thing I'll talk about is what it was like to be a clinical student on this case, which, as I'm sure you all can guess, was absolutely amazing. But I'll say a few more things about that, and I'll try and answer the question of what it was like to try and come back to real class work. But yeah. So really quickly, the jurisdictional question in this case, so in addition to asking for briefing on the primary merits question in this case, which is whether Section 3 of DOMA, which defines marriages between a man and a woman for purposes of federal definitions of marriage, violates the equal protection component of the Fifth Amendment. But in addition to that question, the court asked for a briefing on two jurisdictional questions. The first was whether the United States agreement with the decision of the Second Circuit basically meant that the court deprived the court of jurisdiction over the case. And then the second question was whether the bipartisan legal advisory group, which intervened in this case to defend the statute, had independent standing. So the jurisdictional questions get very messy in this case, and before I get any further, actually, I just want to introduce the other three students who worked on the team with me, Bailey Heaps, Michael Baer, and Nico Martinez. They all did an amazing job on this, and I'm not going to say too much about jurisdiction here, but if anybody has questions afterwards, you can just go to that corner. That'd be great. So on the jurisdictional issues, the United States argued, there were basically four different people arguing things about jurisdiction. So the United States argued that it has standing, it's a party, that there should be jurisdiction, and that BLAG does not have jurisdiction. BLAG in turn argued that they have standing, but the United States doesn't. Then the court appointed amica to argue that the court doesn't have jurisdiction at all. And then we argued that the court does have jurisdiction because the United States has standing and is a proper party in this case, and it doesn't really matter whether BLAG does or not, because if the United States does, then BLAG has piggyback standing. The consensus, like I said, it's a mess. Jake just laughed at me, but it's true. So it's all very complicated, and the consensus generally seems to be that hopefully the court will reach the merits. Again, if people have specific questions about the jurisdictional issues, we can happy to take questions over in that corner afterwards. Thanks, guys. So on the second hour of oral argument for this case was devoted to the question of whether DOMA is unconstitutional. And there are two primary arguments against DOMA's constitutionality. So the first is sort of the standard equal protection argument, which is that it violates the Equal Protection Clause, that gay and lesbian, that it's unconstitutional to discriminate against married couples. So we're talking only about couples who are already married, gay and lesbian couples who are already married in states which allow same-sex marriage. Already married. They're
already gay.
Already gay, already married. Exactly. That was our go-to line at oral argument. They're already gay and they're already married. And so the question then is whether the federal government can, in this particular case, discriminate against Edie Windsor, because she was married to a woman. So what happened in our case is Edie Windsor, who I hope all of you have seen photos or video footage of her. She is absolutely lovely. And if you haven't seen any of those, you should come to the movie at 4:30 today. In any case, Edie and her late wife, Thea, were together for 44 years. Thea, after they were married for the last several years, legally married under New York law for the last several years of their life together. Thea passed away after a long battle with MS, and when Edie filed taxes on behalf of the state, she was hit with an estate tax bill from the federal government of $363,000. So typically, had Edie been married to a man, she would have had a spousal deduction, and she wouldn't have had to pay any of that estate tax. But because she was married to a woman, and the federal government didn't recognize that marriage, even though New York did, she got hit with the estate tax. So the equal protection argument is that the federal government can't discriminate against those same-sex couples or those individuals like Edie, who was married to a same-sex spouse. The other argument that Professor Schacter also mentioned already is the federalism argument. And this does seem to be where Justice Kennedy, if you've looked at the oral argument transcripts, does seem inclined to go. And that argument basically runs along the lines of saying that the federal government doesn't have the right to define marriage, because marriage is something that has historically been defined by the states, and that is a state right to deal with those sorts of issues. But I think also, as Professor Schacter alluded to, trying to make just that argument would be very difficult. And so and I do really encourage everybody to at least read or listen to the second half of the oral argument transcripts, which deal with the merits, because you see a very interesting sort of lineup where you see Kennedy trying to get the Solicitor General to agree sort of that the federal government can't go this far in terms of defining what marriage is. And then you see Roberts try, or maybe the reverse of that order, but you see Roberts try to get the Solicitor General to say, basically, there is no federalism problem here whatsoever. And the Solicitor General obviously doesn't want to cede any power of the federal government really during this oral argument. And then you see Kagan kind of trying to come in and push federalism with the Solicitor General after Kennedy does. So the final thing that you see about the federalism argument, though, is that it may, in this particular case, sort of be tinged with some equal protection arguments. And you do see Kennedy actually say at one point that the equal protection argument and the federalism argument are intertwined in some way. And so I think where that finally gets to in terms of oral arguments is saying that, well, the federal government could sort of define marriage in some instances, but not when it's so motivated, but not when it's against a group that has been historically discriminated against or that is so politically powerless. And again, it's a really fine line of trying to figure out how that isn't then actually an equal protection argument. But I think you do see some evidence of the court trying to sort of marry those two elements. And then the last thing is just my experience as a clinic student, which was, I mean, my legal career can only go downhill from here, precipitously downhill. I was talking to another law professor here, and she suggested that I should just quit at this point and open up a bar or a bookstore or something of that sort. So while I probably won't do that because I have some loans I need to pay back, and I don't think a bookstore or bar will do that for me, this really has been just a phenomenal experience. I can't say enough amazing things about it, from the other students on my team who truly were just marvelous, to Pam, who allowed us to do so much more than we ever thought we'd be able to do with any of this. She let us do a lot in terms of the briefing and just tinkering with things, to finally just seeing how many people it takes and what a collective effort this is, from all the individuals working on amicus briefs to all the individuals who have been involved for so many years in this litigation and pushing it forward and making sure that it comes at the appropriate time, and that the appropriate arguments are set up there. So, and going back to school has been hard.
So I'm going to pick up where Elizabeth left off. I'm going to talk about the people, and then I'm going to talk about the timing issues, then I'm going to talk about the doctrine. On the people, let me say just a couple of things. One is, although this is cause lawyering and it's cause litigation, there's a real client involved in the case. And I want to say two things about the client in addition to go and watch the movie, because the movie is amazing. The first is that while there are some cases where the lawyers go out and find the clients for the case, and I think Perry may to some extent be a case like that, the Windsor case is not like that. Edie Windsor is a longtime gay rights activist in New York. She's been on the board of SAGE, for example, which is a legal services group for gay and lesbian elders. She'd been the pro bono bookkeeper, I think, for Gay Men's Health Crisis at one point. She was a computer whiz. She was one of the first women to work in programming at IBM. And so when she retired early to take care of Thea, who was suffering from MS, she did a lot of pro bono work computerizing the records of various gay rights groups in New York and everything. So she was, unlike some clients in some impact litigation cases, she was already involved in the movement. And when she was socked with this huge estate tax bill, she contacted one of the leading gay rights groups in the country, and they refused to take the case. Ostensibly, I think they thought it was a bad case to bring because she was a wealthy old widow. And they thought that would be a bad case to be the face of this issue, which turns out to have been, like so many of these things, exactly wrong. But at that point, she contacted a lawyer at Paul Weiss named Robbie Kaplan, who's a commercial litigator at Paul Weiss. A friend of hers suggested she do it. And I want to say a little bit that backs up from there about Robbie, because I think this may be especially relevant to a lot of you in thinking about how you want to practice law, which is Robbie has been a commercial litigator at Paul Weiss since she finished clerking on the New York Court of Appeals in the early 1990s, but she's always been doing pro bono work, and a lot of that pro bono work involved gay rights issues, and she was the lawyer who unsuccessfully argued the New York marriage case in the New York Court of Appeals. That is a claim under, as Jane was saying, New York state constitutional law that New York should recognize the right of gay couples to get married. She lost that case in the courts, but that loss, I think, precipitated two things that are really important. One is it precipitated a legislative effort in New York that resulted in 2011 in New York passing, as a matter of just ordinary politics in an extraordinary way, a marriage equality statute so that now couples can get married in New York. The other thing it did is it pulled out of the woodwork the argument that is now the argument being made against marriage equality, which is a fascinating argument because until quite recently, if you argued that marriage should be restricted to opposite-sex couples, the reason for that argument is opposite-sex couples were distinctively moral, and gay and lesbian couples were distinctly immoral, and you shouldn't reward immoral people with the good housekeeping seal of approval. And if you look at the legislative history of DOMA, that's what the House of Representatives says in the House report in 1996, is we are trying to preserve traditional notions of morality and disapproval of homosexual conduct. Well, by the time of the New York marriage case in 2005, 2006, that argument was not as popular as it was before. And so the New York Court of Appeals, when it upheld New York's marriage restriction, upheld it not on the grounds that same-sex couples are distinctively unworthy of respect from the state, but on the grounds that heterosexual couples are distinctively immoral, and therefore you need marriage to keep immoral straight men from impregnating women and leaving them. And that marriage is a way of forcing straight men to support their kids. And since gay couples, the New York Court of Appeals said, spend a lot of time and effort to get pregnant and to have children. That is, very few gay people have children by accident. They don't need marriage to make sure they'll take care of the children they have. And you saw that argument coming out in bizarre ways at the Supreme Court. And I'll say a little bit about the arguments. So Robbie had lost this earlier case, but that case made her someone who was known to be interested in these issues. And so when Edie called Robbie and described what had happened to her, Robbie said it took her like 3 minutes after she met Edie to decide this was a case she would bring. And she brought the case. So that's the first thing. We had a real client. And the second thing I want to say, which ties in with Elizabeth's point about the jurisdictional issue, is the real client made real choices in the case. So after we won the case in the district court, and I say we, although the Stanford clinic didn't get involved until the case was already in the Court of Appeals, but after we won the case in the district court, both the federal government and BLAG, this so-called, surely the strangest name ever, BLAG, the bipartisan, I mean, it sounds like SMERSH or something, doesn't it? But BLAG voted by the bipartisan margin of 3-2 to defend the statutes. And we saw Nancy Pelosi actually at the oral argument, and she said the last vote we had on this was to defend, and since then they just keep shoveling money at, BLAG keeps shoveling money at its lawyers, who've now spent $3 million to defend the statute. BLAG in the United States appealed. And ultimately, in October, the Court of Appeals decided the case in our favor, holding, and this is something that hasn't been talked about yet, but holding not only that this statute was unconstitutional, but that all statutes that discriminate on the basis of sexual orientation should be subjected to heightened scrutiny rather than rationality review, which is a big deal for other statutes that discriminate on the basis of sexual orientation or government policies that do. So at that point, we're the lucky winners in the case. And when the Supreme Court agreed to hear the case and then asked for briefing on the question of jurisdiction, you may notice we've won below. If the Supreme Court has no jurisdiction, Edie Windsor gets her judgment in the district court, which is she's entitled to the judgment was that DOMA was unconstitutional as applied to her, and that she's entitled to a refund of the $363,053 she paid in federal estate taxes. She gets that as well. And so we had a long discussion with our client, a discussion which for obvious reasons I can't describe to you because it's a privileged discussion, but our client made the decision that we would not argue that there was no jurisdiction at the Supreme Court for reasons that have to do with her views of the importance of getting DOMA struck down as well as of getting a refund. And so it's important to understand there's a real client in the case who's making real strategic judgments about what the case is about. So that's the two people in the case that I most wanted to talk about, Robbie and Edie. The timing point. I had a somewhat different understanding than Michael's, but it may be that I just got it from different people, that originally when Ted Olson filed this lawsuit, he did not want a trial. He and Chuck Cooper went in front of Vaughn Walker, Chief Judge Vaughn Walker, and said, we think this case can be disposed of on dispositive motions, and they wanted to get to the Supreme Court as fast as possible. And that it was Judge Walker who slowed the case down. And this goes back to Jane's initial point, which is if this case had gone to the Supreme Court, Perry, or Windsor for that matter, in 2009, I think the outcomes, the potential outcomes in the Supreme Court would be very different than they are today. Because one of the things that these two pieces of litigation have done over time is allowed for a public discussion that has changed dramatically the climate in which the Supreme Court's being asked to decide the case. The climate is totally different today than it was in 2009 with, as Chief Justice Roberts put it at the oral argument, people falling all over themselves to get on your side. I mean, we have the brief of the senators who are now sorry. We have, I mean, that's not what it's called. It's called the brief of, it's a list of senators who voted for DOMA and now say, not we were wrong, but times have changed. We have President Bill Clinton saying, he's not sorry because he doesn't apologize, but he's saying, we now know things that some of us knew then, but others of us didn't know then. And so DOMA should go. The Fortune 500 companies all came in. All of the leading kind of medical organizations and psychological organizations that deal with children or deal with marriage came in on our side. One of the most fascinating things about the amicus briefs is the difference in who wrote the amicus briefs supporting marriage equality and who wrote the briefs against them. Jake was obviously involved a little bit in the military brief. We had 2 military briefs in the case. And so there was this massive change in public opinion that changes how the Supreme Court is facing the issues. That is, I don't think the Supreme Court feels really comfortable in either case. I don't think a majority of the Supreme Court would feel comfortable in saying restrictions on marriage are absolutely okay. And so in Perry, they're looking for a way not to have to say that by perhaps not saying anything at all. And I think in DOMA, they're looking for ways of saying that DOMA is unconstitutional, and the question is which way they'll come up with. So the last point, just very briefly about the doctrine, is there's a lot of doctrine swirling around in these cases. And most of that doctrine is not going to be resolved by the Supreme Court in either of the cases in front of it. I don't think the Supreme Court's going to reach, let alone decide, that heightened scrutiny is required for discrimination on the basis of sexual orientation. But part of the reason they're going to not decide that, in addition to it being unnecessary to resolve the issues in these cases, is because I think the tiers of scrutiny are breaking down in a variety of ways, and that it doesn't even matter so much anymore for the Supreme Court which tier of scrutiny applies to laws like DOMA or other restrictions on sexual orientation, because they're going to find that it's irrational. The second thing is a doctrinal issue that cuts across both the marriage cases and a lot of other cases at the Supreme Court. In Perry, probably the most pointed and widely quoted exchange was an exchange between Justice Scalia and Ted Olson, in which Justice Scalia said to Ted Olson, tell me, when exactly did it become unconstitutional for states to restrict marriage to opposite-sex couples? 1791, it's not clear why he was picking 1791 exactly, because it's not either when the Constitution, I guess maybe he's thinking that's like the end of the ratification and the beginning of the Bill of Rights. I don't know exactly. Maybe if you add up those numbers, you get an interesting. 1791, 1868, right? So the question is, when do practices that are constitutional at one point seem unconstitutional at another point? And I think Ted Olson tried to dodge it a little bit by saying, when did it become unconstitutional to have separate water fountains? To which Justice Scalia said, that was unconstitutional from 1868. But of course, the Supreme Court didn't think so in 1868. It didn't think so in 1896 with Plessy. The Supreme Court didn't think so really until 1954. Now with DOMA, we didn't face quite that question, because when did DOMA become unconstitutional? That's an easy one, in 1996 when it was passed. And if you want a date before that, I guess if the federalism argument is persuasive, then in 1791. But this question of how do you think about changes in circumstance affecting what's constitutional or not cuts across the affirmative action cases at the Supreme Court this term, cuts across cases like the Kiobel case that was decided today. And so it's an important doctrinal issue that, again, we may get some light shed on in this case, but I don't think we'll get an answer to that question, because ultimately there isn't one answer to the question of when do things that were once constitutional become unconstitutional. And that leads to the last point, which is very brief. And that is, whatever happens in the Supreme Court is only part of a much broader movement here, in which everybody understands, I think, that no matter what the Supreme Court decides in these cases, marriage equality is coming, and it's coming a lot faster than people would have thought 10 years ago or 5 years ago. And Edie Windsor was asked outside the Supreme Court at the press conference afterwards, why did she think things had changed so quickly? And what she said, I think, is something worth keeping in mind for all of us as we think about what kinds of lawyers we want to be. She said, because I came out. And she said, because I came out and then other people came out and people realized that it was their friends and their neighbors, that's what changed. And I think the idea that somebody who's 82 had the kind of courage and self-reflection to talk about this all at the Supreme Court is really an inspiration for all of us as we think about like what kinds of clients we want to have and what kinds of lawyers we want to be. So we've left a lot of time for questions from the audience. So questions or comments?
Who is?
Can you guys talk a little bit about, and this is mostly just trying to live vicariously, what it was like at the Supreme Court those days or that day? If you could a little bit. I don't know who all was there. I think
Elizabeth was definitely there.
Yes, I was definitely lucky enough to be. The whole Stanford team was lucky enough to be in in the court to hear oral arguments in the DOMA case, and I wish there were words good enough to describe just how amazing that experience was. I think for me, probably the single most surreal moment was as we walked out of, so after we all came out of the court, or the courtroom and sort of reconvened, we reconvened with Edie and with Robbie Kaplan, who argued the case, and with some other attorneys from Paul Weiss, as well as some attorneys from the ACLU, and Pam, of course. And we then walked out of the Supreme Court. And when you walk out of the Supreme Court, there are 44 steps.
44 steps.
Did you count? There are 44 steps, and then there's this huge plaza out in front that was clear of all people, I would imagine for security purposes. And you had a huge crowd, and on Wednesday it was pretty much all supporters of LGBT supporters of finding DOMA unconstitutional, who were lined up sort of on the sidewalk. And so you walk out, and I walked out with the other Stanford students behind Edie and Robbie and Pam and James Essex, an attorney for the ACLU. And so we walk out of there, and you have this huge white plaza, you have these 44 steps down, and you have this huge group of supporters who start cheering as soon as Edie walks out. And then as she starts walking down the steps, they start chanting, Edie, Edie, Edie. And at that moment, I was like, oh, this must be what it must be like to be, a member of the band for a really big rock star. And so, not that I will ever actually pursue that, although given that my legal career will only go downhill, I don't know. But it was an absolutely, just a surreal moment for me to, quite by accident and being in absolutely the right place at the right time, to be able to feel that I was such a part of a historic moment by being around people like Edie and Pam. And at that moment, I'm at a loss for words. It was that incredible. And so I think for me, it was really just feeling as though this is an incredibly historic moment, and also feeling as though there have been so many people who have been working for so long on this to get us to the point we're at today, and that even after those arguments and those cases are decided or not decided, as the case may be for the Prop 8 case, there is still so much more left to do, but that the amount of support out there for what needs to be done is increasing every day.
Well, and the other thing is just to piggyback on something that Elizabeth said. I mean, it was an amazing moment. I've never had a moment like that before. I was in the courtroom for Bowers against Hardwick, as well. That was the year I was clerking. And the difference between the feeling in the courtroom that day and the feeling in the courtroom this day, it's hard even to describe. I mean, at Bowers, the justices were hostile to the very idea that gay people had intimate lives. You know, Justice Powell, who was generally a very, soft-spoken, gentlemanly guy, was asking questions like, if we let you, if we strike down Georgia's sodomy statute, are public bathrooms going to be safe? What about cars? As if the only people who ever had sex in their cars were gay people. And the justices, went into conference right after, and Justice Powell said in the conference, well, I've never met a gay person. I don't know, like, who engages in stuff. I've never met a gay person. And this time, when you went into the courtroom, I mean, one thing that was a little disconcerting is there were 2 full days of oral argument, and it wasn't until the last 15 minutes of the 2 full days of oral argument that a single LGBT lawyer got to speak in the case, because the government's lawyers were straight men. The lawyers for BLAG were, as Stephen Colbert puts it, super straight, super lawyer, Paul Clement. Ted Olson obviously is straight. Vicki Jackson, the court-appointed amico, is straight. And so when Robbie got up, it was the first time that the LGBT community got to speak for itself in the courtroom. But the court was respectful. There were none of those kind of, there was none of them quoted from the Westboro Baptist Church's amicus brief in the case, a document I highly recommend to you if you want to wear oven mittens while reading briefs. And so the change was just tremendous. I mean, the change in my lifetime in how the Supreme Court thinks about these issues is tremendous. And you really felt that being there that day. And you felt that also in the bar line. We showed up at 5 a.m. to get in the line for the Perry case, because I had a seat at counsel table for Windsor, but I didn't have a seat at counsel table for Perry. And so I got there at 5 a.m. in the morning. And of the first 90 people in the bar line, I knew 85 of them, because it was people who've been involved in the movement in one way or another. It's people who had filed amicus briefs, people who litigated some of the other cases. Mary Bonato was right up in the front of the group. John Davidson from Lambda was there. There were ACLU lawyers. I had former students there who've been involved in doing amicus work in the cases. And so there was this sense when people came out of the courtroom that obviously it matters what the Supreme Court does, but in some sense it doesn't matter what the Supreme Court does, because in the long run, there's been a movement that has fundamentally changed things. And I think at the time of Lawrence, nobody had that. I mean, at the time of Bowers, nobody had that feeling. So that was, for me, I think one of the most amazing things about it was just seeing the change and the rapidity and the velocity of the change.
You also had Edie in her press conference say explicitly that she felt respected during all of oral argument, which I think is incredibly important.
Yeah.
I was struck by the United States seeming unwillingness to make a 50-state argument, and the fact that they seemed like they wanted to stick with this, either limiting to California or limiting it to the 6 states. And I'm wondering if that was sort of a strategic decision, sort of wanting to give the court as much legitimacy as possible and sort of taking that more narrow route, and whether or not you think that's an effective strategy, or if it sort of undermines the whole idea that this is a fundamental right, and sort of the moral and social backing for an eventual 50-state decision.
I think it's a sound, pragmatic judgment. I mean, they have to walk a little bit of a tightrope to get there, and left certain issues unaddressed to do that. But I think, to pick up where Pam left off, the incredible change in public opinion and social change, it's going so fast that you sort of step back and you just wonder whether, at least in the underlying right to marry, not so much DOMA, in the Perry case that you're asking about, whether more by the political process is better than more by the court. I'm not often drawn to theories of judicial minimalism, the idea that courts should systematically do as little as they can and leave as much space for the political process. But in this instance, I think that makes a certain amount of sense. A more incremental ruling, because of the direction things are going in and the possibility. I mean, I don't think that a 50-state ruling at this point would be a particularly positive development for the LGBT community. I think in places like Arkansas and Utah and Mississippi and a lot of other places, there's going to be a lot of resistance on the ground. There's going to be a lot of backlash. And things are going so well with the more state-by-state strategy that was pursued that I think something narrower rather than something broader is better. The thing of it is, though, that the kind of 8-state solution, the idea that a state that already grants civil unions is actually potentially more legally vulnerable than a state that grants nothing is a little counterintuitive to say the least. And that is the idea of the 8-state solution. And I think Michael could talk more about how the amicus brief he wrote kind of framed this in terms of California. But the idea is basically, you know, once you go all the way to comprehensive civil unions, you've taken all the functional arguments out of play. You no longer believe that there are any policy reasons to deny all of the rights that go along with marriage to same-sex couples. So it makes a certain amount of sense under standard equal protection interest analysis to say, well, if you've forfeited all those arguments, you have nothing left because you've already said. But nevertheless, when you stand back and think about it, it is a little counterintuitive. So I think that's kind of the tricky part of it. If you want to talk about your
So there are two parts that comment. I was actually a little puzzled, and Pam may have more on it, why they didn't take just a California only as opposed to the 8-state only. As Jane says, once you move towards civil unions, you have taken the functional argument. But California has gone way beyond the other civil union states in terms of the legislative and other record, our case law. Our brief just was totally a detail of California law. Hundreds of cases going back many, many years as to why the arguments that were being made, the responsible procreation arguments, made absolutely no sense in the context of California law, that you could not put that forth as a rational basis in light of our legislative findings, our case history, the fact that you can't make children the victims to try and change adult behavior, which is what the argument was, that you could jeopardize the children of same-sex couples in order to change heterosexuals' behavior. That all of that was so contrary to California law. We wanted to give the court the narrowest possible ground to rule, and I think that each one of the other states poses a different set of problems. My understanding is that, it wasn't the Solicitor General who came up with the U.S. position, it was the President who came up with the U.S. position. The Solicitor General all the way through this, interestingly, was in a tense position that Pam could talk about, in that the role of the Solicitor General is to defend federal laws. So when the Solicitor General is not defending a federal law, the Solicitor General wants to do that as narrowly as possible in order to preserve what is going to be their normal role. So I thought Verrilli's arguments were all constrained by role and going forward, and I thought he couldn't make the arguments as well. I thought he could have made them stronger if he'd only taken a one-state argument. The opposite side was interesting with Olson, of course. Olson wanting a national marriage thing didn't answer questions in a way, although he obviously recognized that the clients would win in California if it's a state only, not a national thing, and the end obligation is to the clients. But because he was framed on a national, a whole lot of lines of argument weren't made in response. And I think that was an interesting aspect of this case, how each of the lawyers, because they had an agenda other than, as Pam said Edie Windsor was a client and Robbie was focused on a specific client, changes things in a way from when you're an institutional lawyer or when you have a bigger agenda like Oslin or Verrilli had.
Well, and the government also had this other weird problem when it came to Perry, which is they decided, at the time they were faced with the question of what standard of review should apply to discrimination on the basis of sexual orientation. They were in the DOMA cases as a defendant, but they had nothing to do with Windsor. And so they announced a rule that really, if you take it seriously, requires a 50-state solution. That is, if intermediate scrutiny applies to restrictions on marriage on the basis of sexual orientation, then every state's law goes down. They all rise or fall together. And the government didn't want to say that. And I think that's part of what was driving them because of the things that Jane was pointing to. So that leads them to try and find some solution that's kind of marriage specific in Perry. And there are ways in which the 8-state solution as a doctrinal matter, as folks have already said, is perfectly coherent, but it does have a somewhat odd quality to it. But for obvious reasons, political reasons, the administration isn't going to want to argue for a 50-state solution.
So, as much as it does feel like the argument is pointing towards justice and equality, what do we do if there is a decision that doesn't go the way that we want it to directly, right? So same-sex couples, what's the next step, especially if Perry doesn't go?
Well, I think if Perry loses, we're going to win a ballot proposition in California. And so, a lot of the reasons that people didn't want to go the Perry route was it was 52-48, 6 years ago, and the conditions have changed so much that a ballot initiative would flow easily there.
And if the Supreme Court, if the Supreme Court reaches the merits on the DOMA question and upholds DOMA, then the next time the Democrats get both houses of Congress, there'll be a repeal of DOMA.
Yep.
I have a particular interest in this discussion in relation to its impact on the notion of marriage in a heterosexual situation. So, for example, the Supreme Court has a ruling that a mother, or if we assume parent, has the right to raise the child from a child welfare perspective in the way that they govern its bit in relation to American tradition, and then the disparity between private and public law in relation to child welfare. So I understand there are three particular arguments on the table here. However, I am hopeful, and I'm welcome to your opinions, on the levelling of discrimination and equal opportunity through this discussion in a sideways approach to heterosexual marriage and divorce.
Could you frame it a little more? I'm not sure I'm quite getting it.
So what I'd like to see is your opinion on the structure of marriage, divorce, and child welfare as a notion between whatever gender the couple is. So do you see progress being made into the issues for man and woman marriages in relation to marriage itself, divorce, and child welfare?
Well, I don't think it's concrete or one naturally follows the other, but what came into my mind when you were talking was Judge Walker's opinion, which said that among the many constitutional failings of Prop 8, and he had a whole list of them, was that it was gender discrimination. And he, I think somewhat optimistically said, the time for any gender differentiations in marriage has long passed and is over. And so in this, brave new world that we live in of complete gender equity and equality, there's no room for this kind of discrimination. Now, some people thought that was an invitation to really look at the idea of gender equality and take that ruling and try to use it as a building block for, some reforms that would transcend the particular context of same-sex relationships and would kind of, reconceive marriage as genderless in some ways.
So I just extrapolate the notion in that, so I've been married and fully divorced and was astounded at my experience with the American divorce system. I've been a globalist even the discrimination that I as a mother and a female would experience. And so the reason why I'm ecstatic, apart from respect for all individuals, is that I think marriage as a notion needs to be completely upgraded. So in a way, I have many gay friends, and I look at them and wonder, why exactly do you want to get married? Because who is going to have the debate? Yes, I'm going to be the subordinate who's going to do the housework. Do you understand what I'm saying? Like, we need to frame what is marriage.
Well, I mean, one point just from the perspective of representing Edie Windsor is the reason she wanted her marriage recognized was twofold. One is because it is the expression of public and official respect for her relationship, and the other is because there's a huge list of tangible benefits to her. So she's not asking to have the institution of marriage remade. That wasn't why she brought the lawsuit. She was bringing the lawsuit to get access to the institution as it now exists, which is, as a public matter of federal law, is, while not entirely egalitarian, is quite heavily egalitarian. That is, there are very few rights under federal law that are given to female members of heterosexual marriages that are not given to male members. Most of those laws were struck down in the 1960s, 1970s, and 1980s. So her claim is not about remaking the institution of marriage. And indeed, to the extent that people make a claim that they're trying to remake the institution of marriage, it becomes much harder as a legal matter to make the argument that this is about equality, because generally the equality argument is we should be treated the same. And if you're making an argument that the whole system needs to be remade, you're not making an argument about equal access to the system. You're making a very different kind of argument. And that's not what she wanted to make.
Yeah, no, I think it's an excellent step forward. And I'm really hopeful there'll be more progress. Without going into the intricacies here, there are flaws that need to move into lines. So I think it's a wonderful step forward, and I hope to see more evolution.
We have time for one more, or no?
I don't.
Oh, okay.
If we could all join and just say thank you.
It's all downhill from here. That's the takeaway.
That's the takeaway. No, really. It was Juliet that told me that. Actually.
Yeah, I knew.
She was like,
no doubt.
yeah. No, but thank you guys for letting me hang out with you.
Yeah, no, that was really fun.
It was fun to co-law Professors for a day.
Thanks, Elizabeth.